week and is considered by the school, say in Our Lady of Guadalupe.
Well, we can press on. Senator Tillis.
Judge Barrett, thank you again. 4 cases: U.S. versus Lopez, D.C. versus Heller, Hobby Lobby versus Burwell, Washington versus Glucksberg. Were they correctly decided? Got to put your mic on.
Is it working now?
Yeah.
Okay, good. Senator Tillis, I can't express a view on the correctness of any precedent.
So I think it's pretty clear that it's not just cases favored by my Democratic friends. You're taking a very consistent position, and I think the American people should understand that. Thank you. I had a sheriff in Wake County. In North Carolina, you have to apply for a permit to purchase a handgun in North Carolina. And for a period of time, the sheriff of Wake County refused to process handgun permits. He has subsequently reversed that policy, so it's no longer an active case. But, it would seem to me that sheriff was making a decision that wades into, I think, a Second Amendment right. How would you evaluate a case like that if it came before you?
So if a case like that matured into litigation and went up the appellate process, I would look at the law, and obviously the Second Amendment would be relevant there. So I would, read all applicable precedents, including Heller, to determine whether what the sheriff had done violated the Second Amendment right or not.
Well, I think in that case it did, but I would leave it to somebody far more qualified than you to take it forward. And I suspect it will if the sheriff reimposes the same imposition on lawful gun owners. I thought about this when Senator Hawley was asking a similar question. I've finished my 68th telephone town hall since the first case was reported in North Carolina. And about a month into it, everybody understood that we had to shut things down, try to understand how COVID was affecting us. But then about 4 to 6 weeks later, we saw peaceful protests, some of which were hijacked, and we've seen them widely reported, allowed by certain liberal governors and other elected officials in towns and counties. But at the same time, they prevented churches from being able to worship. You enumerated the protections, the specific protections under the First Amendment, and I think religion and protest are 2 of them. Do you feel like any governmental entity has a right, on the one hand, to allow these protests to occur, and on the other hand, prevent worship in temples, synagogues, mosques, or any place of worship?
Well, Senator, those kinds of cases are being litigated all around the country right now. Some have gone up to the Supreme Court on a couple of different orders, so those aren't things that I would be able to comment on.
Are you able to opine at all on how you would go about evaluating the arguments?
Sure. So whenever you have that kind of a restriction, like, as we are in a pandemic, the Supreme Court's general position is that the government has a compelling interest in responding to a health crisis of this sort. So you look at the case law describing the extent of the state's authority to address a public health crisis. It's come up before in a case involving vaccination. Then you also, and this was clear in my interchange with Senator Hawley, you also look at the other amendments and other rights at play. So in the case that I had, it involved the First Amendment, looking at the speech and free exercise clauses of that amendment. So those come into play as well.
Thank you. When I met a couple of weeks ago, I have to thank you again. My daughter was thrilled that you signed the 2 pocket constitutions for my 2 granddaughters, and they'll cherish it someday when I can explain what it really means. It's going to take a few more years. One is 3 and the other one's 8 weeks. But I really enjoyed that discussion, and I ask you there something I'd like for you to share with the committee. You have stellar academic credentials. You have stellar record as a professor, and you've done an excellent job on the 7th Circuit. You've been a great mother and wife. You have so many options. There are so many things that you could be doing besides going through the first confirmation hearing, which was not pleasant. I was here and I remember it. And you knew that this was even going to be more challenging. So I asked you when we met, why would you do this, knowing how this was going to play out, knowing that you were going to be attacked and unfairly treated, and I think to a level of maybe where some of your constitutional rights have been questionably denied. So why are you doing this, Judge Barrett? Why not just say thanks but no thanks, leave it for somebody else?
Well, as I said to Senator Graham yesterday, and I think this was part, and parcel of the conversation that you and I had, that this is a very difficult process. Actually, I think I would use the word excruciating over the weeks, and the knowledge that, people are going to say horrible things, that your entire life will be combed over, that you'll be mocked, that your children will be attacked. And so one might wonder why any sane person would undertake that risk and that task unless it was for the sake of something good. And as I said yesterday to Senator Graham, I do think the rule of law and its importance in the United States, and I do think the role of the Supreme Court is important. It's a great good. It would be difficult for anybody in this seat. I think everybody knows the confirmation process is very difficult, and so for me to say no, other people could do this job, but the same difficulty will be present for everyone. And so for me to say, I'm not willing to undertake it, even though I think this is something important, would be, a little cowardly, and, I wouldn't be answering a call to serve my country in the way that I was asked. I also think in our conversation, I said, that my children were part of the reason not to do it because, my son Liam got very upset yesterday during the questioning, and so, we had to call him in the car. He didn't stick it out to the end. I was surprised he stuck it out as long as he did. But Liam got very upset at the questioning, and Senator Kennedy referenced some of the other things that have happened to the children in the process, and so I said to you before any of that happened that in many ways the children are the reason not to do it, but they're also the reason to do it, because if we are to protect our institutions and protect the freedoms and protect the rule of law that's the basis for the society and the freedom that we all enjoy, if we want that for our children and our children's children, then we need to participate in that work.
Well, I think you're an extraordinary role model to a lot of people watching. I agree with Senator Blumenthal. A lot of people are watching this, and I hope that every one of them conclude that you're a courageous person and you're a public servant. With your credentials and your experience, you could move out of public service and do virtually anything you wanted to and have more time with your family along the way. And the fact that you're willing to serve is just, I think, an extraordinary testament to your character and your integrity, and I appreciate you for it. The other thing I wanted to get back to is on the issue of abortion. I think it's remarkable over the course of the past couple of days how many times they have, my colleagues on the other side of the aisle have challenged you on this matter. And in the same breath, they're advocating for activism. In one breath, they want to secure certain Supreme Court precedent. On the other breath, they want your commitment to potentially overturn it. But I want to talk specifically about a policy in Gonzalez versus Carhart. I mentioned yesterday late-term abortions, partial birth abortions. I've thought were horrific all of my life, but especially since I held that premature granddaughter of mine who was born 3 weeks premature. How would you, if a case as a matter of state law or federal law, let's say Senator Graham's bill, how would you go about evaluating maybe some laws that would prevent late-term abortions, partial birth abortions? How would you go about evaluating that in light of Gonzalez versus Carhart?
Well, I would look at all the precedents. Casey, as we discussed yesterday, sets out the undue burden standard, which is the test, and then Gonzalez versus Carhart, as you say, upheld a restriction on partial birth abortion. Whole Women's Health and June Medical are the most recent cases in the abortion line. So if I were to have to decide a case involving a bill like the one that Senator Graham has referred to, it would involve looking at all of those precedents and their application to the particular contours of the law that was before me.
Thank you. Now I'm going to go in a slightly different direction. I was talking with Senator Coons, who is the ranking member on a committee that I chair, a subcommittee here on intellectual property. We've done a lot of work, and we're working on a bipartisan, bicameral basis, and I have to thank Senator Blumenthal for probably being one of the more active members in this committee. I think it's an area where we really are working on a bipartisan basis, the things that the public seldom see. But I want to ask you first on antitrust. I know a district court opinion sided with Federal Trade Commission that found that Qualcomm violated antitrust law. And the Ninth Circuit overruled that district court decision. I don't know if you followed it, but in the Ninth Court opinion, they said that Qualcomm was a company just asserting its economic muscle with vigor, imagination, devotion, and ingenuity. I know you can't speak to that case, but I'm interested in your thoughts generally on antitrust law. Where do you think the court should draw the line on federal antitrust limits between where a company violates an antitrust law or, as Qualcomm was characterized, of just asserting its economic muscle with vigor, imagination, devotion, and ingenuity?
I haven't followed that case, so I'm not aware of that case from the Ninth Circuit, but I would be venturing out into that hypothetical dangerous territory if I tried to articulate what hypothetical line to draw in the context of antitrust law because, well, as you probably know better than I, just being on the committee, it's a complex area with lots and lots of precedent and lots of statutory and regulatory law as well.
Moving to another area that's been addressed on the Committee on Intellectual Property and Patent Law Eligibility. As judge, I should say, as chairman of the subcommittee, I'm really interested in protecting the intellectual property of the American innovation economy. There's no question that we're the leader in the world. But in recent years, we've seen a lot of Supreme Court cases that have waded into patent eligibility, producing a series of opinions that have really muddled the waters. And in some cases, I think that I agree with the decision, but I worry about the methodology that they use to get there. So I'm curious about your thoughts. In my committee, we've talked about specific cases that we could potentially abrogate if we could get bipartisan support, and we're in those discussions. But what are your thoughts on the Supreme Court's rulings on patent eligibility? And do you think that the court should go back and clarify at least the method that they use to reach their opinion?
So without commenting on any particular cases, which actually I have to be completely honest and confess to you, I can't think of what particular cases you might be thinking of in the patent eligibility, but without commenting on those cases in any event, I think I would say that clarity in decision-making is always something that courts should strive for, and I know on the Seventh Circuit, we try, and I'm trying to be attuned to in writing opinions, whether it gives good guidance to lower courts and then to also those who are trying to order their conduct, in compliance with the law. So I think clarity is certainly a virtue in this context.
And I think that we're working, like I said, on a bipartisan, bicameral basis to help or do it on our part. Copyright law and technology is another area that we focus quite a bit on. I think I had one witness say that our current laws are MySpace laws in a TikTok world. There's a lot of changes that have occurred, and we feel like there's a need for us to maybe move forward with some clarity and some protections. The Supreme Court has spent more than a century answering questions about whether copyright law covers new technologies like cameras, player pianos, moving pictures, the list goes on, several internet-enabled technologies. Do you think that the Supreme Court is the best institution to answer these questions, or is that a role Congress should play?
Most of the things you're identifying sound to me like matters of policy, and so those seem like matters that are best addressed by the legislature, a democratically elected body, not policy made by courts.
I agree. I think it's a complex subject, and I'm glad to hear your opinion, and I hope that we make progress on it. And again, I have to thank Senator Coons and Senator Blumenthal and Senator Hirono, who are on that subcommittee, I think we've worked well, and I'm hopeful that we'll make progress. I think Senator Blumenthal asked you about the courts getting involved in elections, but before somebody goes out into the cyber world and says 9 people are going to decide the outcome of the election, 9 votes versus the tens of millions of votes that are being cast now will be cast by November the 3rd. What you're potentially going to be confronted with are various lawsuits that may come in based on changes in voting protocols for this cycle versus other ones. But at the end of the day, what role is the court going to play, if any, in the determination? 9 people are not going to elect the president, regardless of who wins the election. But 9 people are going to have to consider various cases. But at the foundation, is it accurate to say that your role will be determining whether or not every single American who wishes to vote had their vote recorded and was given proper access to make that vote? Is that fundamentally what the courts would decide?
Fundamentally, if an election dispute arose, obviously the issue, it's impossible to predict what particular aspect of the election would be challenged. But the laws that would be invoked are laws that protect the right to vote, that keep elections fair. So those are the kinds of issues that have come up in past election disputes. And so certainly the court would not see itself as, and would not be electing the president. It would be applying laws that are designed to protect elections and protect the right to vote.
I also want to thank you in closing, Mr. Chairman. I want to thank you for reaffirming, I think in a discussion with Senator Durbin, possibly Senator Hawley, that you believe every single person in this country should have a right to vote and that they should be able to do that without intimidation, without any undue burdens. And I appreciate you reaffirming that. And I just want to make sure I heard you right in your responses to other questions. You do feel very strongly that every American should have safe access to the vote. And I, for one, hope that every registered voter in this country vote on November 11th. That may be a stretch goal, but do you agree with that?
Of course, yes.
Thank you, Judge Barrett, and thank you for your family for enduring all the challenges that you have. Thank you for your courage, and thank you for your integrity. I look forward to supporting your nomination.
Thank you, Senator.
Senator Hirono.
Thank you, Mr. Chairman. Today we're going through this hearing as though it's a normal hearing, not a rush job in the midst of a pandemic, 200,000 Americans dead, no pandemic relief bill in sight for the American people, the fate of the ACA at risk. But the Democrats on this committee have asked and will continue to ask you questions to let the American people know that your being put on the Supreme Court will dramatically flip the balance of power to the court, further to the right, not the fair, impartial body we want the Supreme Court to be. Judge Barrett, yesterday you told Ranking Member Feinstein, quote, if there were policy differences or policy consequences, those are for this body. For the court, it's really a question of adhering to the law and going where the law leads and leaving the policy decisions up to you. That would be us in Congress. The effects of this distinction you made between law and policy, a distinction I described yesterday as artificial, can be seen in a case from earlier this year. In Cook County v. Wolf, you considered the Trump administration's dramatic change to the public charge definition, a wealth test to prevent low-income immigrants from entering the United States or becoming permanent residents. The majority found the rule had, quote, numerous unexplained serious flaws and barred its imposition. You, on the other hand, issued a 40-page dissent calling the rule reasonable. You would have allowed the Trump administration to limit low-income immigrants who might become a public charge. You called this rule reasonable despite the harm you knew it would inflict. For example, Illinois has approximately 3.1 million people enrolled in Medicaid, including 388,000 non-citizens and 341,000 citizen children with an immigrant parent. It estimates over 140,000 individuals will disenroll from benefits and public services as a result of the public charge rule. Nationally, about 1 to 3 million people have disenrolled or gone without Medicaid coverage due to fear of consequences from the application of the rule to them. Dana, a community service provider in Colorado, can tell you about a single mother who didn't want to enroll her autistic U.S. citizen child in necessary health and education services. Dana can also tell you about a pregnant woman in her 3rd trimester who sacrificed prenatal care. The effect of the public charge rule has intensified as people forego testing and treatment for COVID-19, ensuring people will be sicker, more likely to die, and more likely to inadvertently spread the virus. Sarah, who helps provide legal assistance in New York, works to lessen the devastating, impact of the rule. This includes working with one immigrant living in a shelter seriously ill with COVID-19 symptoms and unwilling to get tested or treated out of fear for her status. And while the Trump administration admitted the rule's connection to a reduction in public benefit enrollment and food insecurity, housing scarcity, and increased costs for states and localities, it brushed off the impacts and refused to alter the rule. Similarly, in your dissent, you also acknowledged that people are disenrolling from health and other programs out of fear. You not only admitted to the disenrollments, you found it unsurprising. Disenrollments reportedly affect nearly one-third of all low-income immigrant families with children. Judge Barrett, just to be clear, do you believe these disenrollments are policy consequences that are the job of Congress to fix, not the courts to consider?
Senator Hirono, the dissent that I wrote in Cook County went through the public charge rule and the statute to explain that those who are currently receiving benefits were not affected by the public charge rule. It was a prospective screen.
Actually,
but I agree with...
Excuse me, Judge Barrett. I read your dissent, and I know you went through the laborious, you tried to show the people who would actually be impacted by the rule, but in your dissent, you also acknowledge that there are a lot of people who are not impacted by this rule who will disenroll because of fear that the rule would apply to them. So my question to you is whether those kinds of effects, which you foresaw, you even acknowledged it, if you think it's appropriate for the court to consider those effects.
So Senator Hirono, as I was trying to answer before, yes, I said that there was fear and there was disenrollment, but that in fact the rule did not apply to anyone who is currently eligible for benefits. The question of disenrollment and the effects of the rule would be relevant at the stage of arbitrary and capricious review. I was just analyzing the first step, which was the interpretation of the statute. But I said that I wouldn't reach the question in that case because it hadn't been briefed. So what I said in my dissent was that it would be better to send that back to the district court for briefing on the question of whether the rule and the evidence that the agency had gathered was arbitrary and capricious, including its treatment of the costs for state and local governments, et cetera.
Judge Barrett, you deem the rule to be reasonable. So I take it you stand by your dissent in that case.
I stand by my dissent, but Senator Hirono, there is a difference between reasonable under the Chevron doctrine and arbitrary and capricious under the Administrative Procedure Act. So just what I'm clarifying is I did not.
But as you noted in your dissent, the APA was not even brought up, so that was not an issue. So everyone seems to agree that this rule is having a chilling effect nationwide among families, affecting access to health care, nutrition, food, housing, benefits that Congress meant to make available. So I would say that from your response and the response you gave to Senator Feinstein about the distinction you make between policy and law, it seems to me that in this case, you did not give much credence to the effect of this rule.
It wasn't,
albeit the rule did not apply.
it would have been the question at the arbitrary and capricious stage because that's one of the relevant factors. But, the laborious study that I did in the public charge case responded to the arguments the parties made and the complex statutes that Congress has passed in this area, including the welfare reform.
Judge Barrett,
Yes?
I'm sorry too, I don't think you even mentioned arbitrary and capricious standard. So let me move on. Yesterday, Senator Graham asked you about how unlikely it would be to overturn Supreme Court precedent on a range of issues. And you said, quote, judges can't just wake up one day and say, I have an agenda. I like guns. I hate guns. I like abortion. I hate abortion. And walk in like a royal queen and impose, their will on the world. You have to wait for cases and controversies. But I don't think that's an entirely accurate picture, because certain justices have been using their opinions to signal interest in addressing various issues, particularly those undermining workers' rights, civil rights, even inviting challenges to longstanding precedent. In fact, as Senator Whitehouse explained this morning, just 2 years ago, the Supreme Court overturned a 41-year-old precedent. Talk about reliance on a precedent. This precedent was called Abood, which protected public sector unions, and Justice Alito engaged in a six-year campaign. And I just have this chart to show you that he was very persistent in signaling that he wanted to revisit Abood. So in 2012, Justice Alito first signaled that he wanted conservative anti-union groups to challenge Abood in his decision in Knox v. SEIU. These groups brought case after case to meet the criteria Justice Alito laid out. Although they came close in 2016, his plan was thwarted by Justice Scalia's death, which left the court stuck in a 4-4 decision, tie, and Fredericks. Justice Alito had to wait until Senator Mitch McConnell blocked Merrick Garland's nomination for nearly a year as President Trump, so that President Trump could appoint Neil Gorsuch. Pretty much the minute Justice Gorsuch got on the court finally overturned Abood in Janus. Now we're seeing that same kind of signaling to invite challenges to another precedent. I mentioned this yesterday, Obergefell, which recognized the right of same-sex couples to marry. And last week, the court denied review in over 1,000 cases, but Justice Thomas, with Justice Alito, issued a sharply worded statement about one case that was denied review, Davis v. Ermold. And that case involved a former Kentucky clerk who refused to issue marriage licenses to same-sex couples after Obergefell. So like Justice Alito in 2012, Justice Thomas, joined by Justice Alito, signaled an eagerness to roll back a Supreme Court precedent that they believed conflicted with their understanding of the Constitution. They criticized Obergefell for, quote, reading a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text, and called it a problem that only the court can fix. Judge Barrett, you said judges have to wait for cases and can't say, I have an agenda. But here you have examples of justices who are sending out signals. Bring these cases to us because we want to take a look at precedent. I just want to cite one case where I think that you are also sending out a signal, and that is a circuit court case. Well, two circuit court cases. One that has you've been asked about, Cantor v. Barr, where you wrote a dissent arguing that certain people with felony convictions should have the right to have a gun, and you went out of your way to raise the issue of whether their right to vote, about their right to vote, and raising concerns that you view their right to vote to be more limited than their right to own a gun. In another example, in Price v. City of Chicago, in that case, you joined a decision that upheld the so-called abortion clinic buffer zone law. As a circuit court judge, you had to apply the law under clear Supreme Court precedent. But the decision that you joined went even further. It signaled a strong disagreement with that precedent, the Supreme Court precedent, calling it, quote, incompatible with the First Amendment and imposing serious burdens, and directed the plaintiffs to seek relief in the Supreme Court. You are going to be, if confirmed, on that Supreme Court. Earlier today, Senator Coons showed you a chart of more than 100 cases where Justice Ginsburg was in the majority and Justice Scalia was in the dissent. And the chart showed the many rights at stake, including long-standing precedent with your nomination. And that includes workers' rights, civil rights, health care, campaign finance limits, and environmental protections. My Republican colleagues are well aware of this, and that's why they want you to be on the Supreme Court so badly. In 2016, after Justice Scalia died, you described him in a TV interview as the staunchest conservative on the court. Is that correct?
I can imagine that I said that as I'm sitting here. I can't recall my exact words.
Well, I'm quoting you, so
Okay.
yes, you said that. And you also recognize that replacing the staunchest conservative on the court with someone nominated by President Obama could dramatically flip the balance of power in the court. That's a quote from you. Could dramatically flip the balance of power in the court. You are now in a position that you described 4 years ago of dramatically flipping the power of the court. So your nomination would actually be more dramatic, a more dramatic shift. Law professors such as Professor Stephen Vladeck have pointed out that with your confirmation, the court would be transformed into the most conservative court since the 1930s, with a much more aggressive conservative agenda. In accepting your nomination, you described Justice Scalia as your mentor. That's been mentioned many times before. It appears that you may be even more to the right of Justice Scalia, whom you described as the staunchest conservative. I think it's important to look at what kind of impact you would have had on more recent Supreme Court decisions. When Justice Ginsburg served on the court, the Roberts Court issued numerous 5-4 partisan decisions. But what's notable are the more recent 5-4 decisions after Justice Kennedy, who was often in the middle of the ideological spectrum, was replaced by a much more conservative justice. The court shifted rightward as Chief Justice Roberts' conservative views was now in the middle of the ideological spectrum of the court. So, Judge Barrett, are you familiar with the recent 5-4 decisions where Chief Justice Roberts joined the 4 liberal justices to form a majority?
What decisions are you referring to?
Are you familiar?
I don't know what decisions you're referring to.
There are a number of them. I would just touch on 2, and I'll describe them. So these 5-4 cases touched on several issues that highlight what's at stake with your nomination. These issues include protections for DACA recipients, the integrity of the census, reproductive rights, digital privacy rights, right of criminal defendants, COVID-19 safety measures, protecting agency regulations, covers a wide range of protections from veterans' benefits to clean air and water. I'm just going to go to the DACA decision that I mentioned in June 2020. Justice Ginsburg was part of a 5-4 majority with Chief Justice Roberts that blocked the Trump administration's efforts to end the DACA program. And replacing Justice Ginsburg with a conservative like Justice Scalia would have thrown the lives of 800,000 DACA recipients and their families into chaos. The DACA participants would be facing deportation. That includes the over 200,000 DACA recipients who are risking their lives on the front lines of the pandemic to protect the health and safety of us. And last year, Justice Ginsburg and Chief Justice Roberts issued a 5-4 decision that blocked the Trump administration's anti-immigrant policy of adding a citizenship question to the 2020 census, something very near and dear to President Trump. And replacing, in that case, Justice Ginsburg with someone like your mentor, Justice Scalia, would have resulted in excluding many immigrant families from the census. That would not only have decreased their representation in Congress, it would also have decreased their share in the distribution of $1.5 trillion and federal resources. And yesterday, we saw what the court looks like without Justice Ginsburg on it. It allowed the Trump administration to end the census data collection early, despite the ongoing pandemic, despite the fact that they will not get an accurate census count by ending the data collection early. So, of course, that would mean probably fewer federal resources for communities where there is not that accurate count. That could also mean that Trump officials, instead of Census Bureau experts, may use the population numbers to determine representation in the House of Representatives and in state and local governments. And we already know that Trump is demanding that those numbers exclude undocumented immigrants, even if the census requires everyone to be counted regardless of immigration status. So President Trump has repeatedly accused Chief Justice Roberts of betraying conservatives in the court's decisions on health care, DACA protections, and other rights. He's made it clear he has nominated you to do the job he thinks Chief Justice Roberts and Republicans failed to do: strike down the Affordable Care Act and roll back critical rights and protections. You've already been asked about the consequences of the Shelby County decision. It was totally foreseeable that you would have a lot of states passing voter restriction, suppression, basically laws. Do you believe, Judge Barrett, that voter suppression or discrimination in voting currently exists?
Senator Hirono, we have the Voting Rights Act that offers protection, and Section 2 of the Voting Rights Act, which was not at issue in Shelby County, protects voters from any kind of measures that would discriminate on the basis of race, and so that gives protection.
Do you think that the Justice Department is pursuing aggressively those sections of the law? Because we know that over a dozen states passed what I would characterize as voter suppression laws. So that is obviously happening. Now, in that case, Justice Thomas went even further because the majority in Shelby County left the framework for allowing Congress to come back with formulas that would enable preclearance to occur. But Justice Thomas went even further. He said, get rid of the entire framework. Congress, you're totally out of the picture. So this is the danger we're facing with your being put on the court. One more thing. I have just one more question. Do you think that having 3 justices who have worked on the Republican side, Bush v. Gore, you're one of those justices, should you be confirmed, creates an appearance of conflict if an election case involving a president who nominated you comes before the court? And I'm basically out of time, so I'd like a yes or no answer.
Well, Senator Hirono, I answered that question before and said any question of whether there was an appearance of partiality problem would be one for all justices involved to consider under the recusal statute.
So you think there might be a conflict and therefore you would have to go through that entire
Senator,
process?
I think anytime someone makes a motion to recuse, and indeed even one is not made, a judge always has to consider that issue. So, I mean, you're asking me to make a decision about whether I think myself and 2 people who are not even yet my colleagues should recuse in that situation, and I'm just saying that I...
No, but actually my question was whether it poses an appearance of conflict, and I believe that the fact that you would even bring forth the recusal process says to me that voters might decide that there is an appearance of conflict. Thank you, Mr. Chairman.
Thank you. Senator Ernst.
Yes, thank you, Judge Barrett, very much for being in front of us. Welcome to day 3. It's been quite a day, and because we do have so many members that have been busy talking over you and interrupting, and they've said so themselves. Pardon me for interrupting you, telling me that their time is more important than hearing your answers. If you would like to take a few moments, if there's anything that you would like to further explain, I would welcome that at this time.
Thank you, Senator Ernst. I mean, I think the only thing I'd want to clarify is, you know, insofar as Senator Hirono was suggesting, I think that the work that some of the justices may have done on Bush v. Gore is reason to recuse, that is certainly not what I meant. What I meant is that in every case, judges have an obligation to consider the issues, and they may conclude no. So what I meant to be saying was just not to take a position, so I just want to make that answer clear.
Great. I appreciate that. Thank you for taking that time. And Judge Barrett, obviously, over the past number of weeks since you were nominated, and certainly since this hearing began, there's been a lot of discussion about the legacy of Ruth Bader Ginsburg, who was really a trailblazer. The Democrats seem to claim that you wouldn't be an adequate replacement for Justice Ginsburg because you do not march in lockstep with her judicial philosophy. The way I see it, you're both trailblazers, and you're both accomplished professors. You were both respected and revered and had strong endorsements, both from the left and the right. And you're both amazing working moms. You both served in private practice. And like you, she was a woman of strong religious faith. And you both have a very impressive track record on the judicial bench. So asking women to march in lockstep with one philosophy is exactly the wrong kind of message we should be sending to women, and especially to young women. What I hear so often from the left, many of us on the right do, I would say probably Senator Blackburn hears this, many others hear this, that because we don't hold the same views that those on the left do, we shouldn't be serving in the roles that we are in. And that's what the left is projecting on you, is because you are not lockstep with what they want to see in their nominees, that you aren't worthy of serving on the bench. I don't believe that. I don't believe that. And that shouldn't be the litmus test for the Supreme Court, and frankly, it shouldn't be the litmus test for any woman in any job. Any woman in any job. Diversity of thought and an ability to pursue her dreams is exactly what the women trailblazers of the past fought for. If the suffragettes hadn't been willing to go against the men of their time, certainly none of the women sitting on this dais would have the opportunity to question you today. So what would you say to those that claim you are not an adequate replacement for Ruth Bader Ginsburg because you do not march in lockstep with her judicial philosophy?
Well, I think that judicial philosophy is an appropriate and an important topic for this committee to explore at the hearing. And I think each of the senators has a responsibility when a nominee comes before you to ask what the judicial philosophy is. And I think disagreeing with the judicial philosophy that I or any other nominee had is perfectly admissible grounds for voting no, because you may have a different vision for what a justice or a judge is to do, and so I have no problem with that. I mean, I think that is how the senators on this committee have viewed their role, and so to, on philosophical or, jurisprudential grounds, I mean, I think that's part of what, or, a lot of what this hearing should be about. I think that there's room on the court, and I don't think this just in terms of the women, but I think this for all members on the court, there's room for different approaches to the Constitution, and I think those approaches shouldn't be broken down into partisan boxes, because judges are not partisan. They do get appointed and confirmed by the political branches, but judges don't have campaign platforms, and they no longer associate, as I've said a number of times through the hearing, judges stay out of politics. So their jurisprudential philosophies are not designed to yield particular results. So I think there's room for different jurisprudential philosophies that, by the way, even when they start and approach texts from different ways of thinking about it, sometimes yield the same result. It's not necessarily the case that two justices who, one being a pragmatist and one being an originalist, won't end up at the same place. They just might get there a different way. Or even originalists, I mentioned yesterday that, there are many who identify themselves as progressive originalists. So originalists, could start at the same place, and, I suspect that, they would disagree, end up in different places, and I've given examples of that. So I think there's room, and it's good and healthy for different approaches to the Constitution and to have debates about that.
Thank you. I really do appreciate that answer. So as we've been sitting through these discussions, I've heard a number of my colleagues bring up different descriptive words to describe you, and I'd just like to review a few of those right now. Respect, intellect, character, jurisprudence, clarity, demeanor, humility, dignity, independent, exceptional. I think that you are exactly what we should embrace. And as I look at future generations of men and women that might want to serve on our Supreme Court, I hope that they would espouse those attributions as well. And while we have this national stage, I would like you, Judge Barrett, to share some grains of wisdom for those future generations. What advice would you offer to those who are just now embarking on their legal career, and how should they define success and find motivation to, kind of, quote, leave their best on the field, if you will, at the end of each day?
Well, I think, I loved the practice of law. Some professors go to the academy because they don't enjoy practice that much. I actually really, really enjoyed practice, and then when I went to the academy, I really enjoyed that too. I would say that, especially when you're beginning your legal career, often you're at an earlier stage in your life when you may have fewer other obligations or fewer family obligations and maybe more energy. So that it's, I guess I would just say, live life to the fullest, seize all of the opportunities you have, and do your best. But at the same time, never let work crowd out all of the other precious things in your life, like friends and family and faith and exercise. I had a law professor who told first years who were very, very anxious and studying hard in exams to make sure that you gave yourself time to go take a run. Or go work out. I mean, I think all of those things that make up our lives apart from work, can't be shoved aside. At the same time, however, you should seize opportunities and pursue them while keeping in mind your whole person.
Yes, the whole person. Thank you. So when we sat down, Judge Barrett, I told you a little bit about my daughter, Libby, and she's studying pre-law right now. And she sent me a text this morning as we were in this room. And she said, I have to fisk an article on Judge Barrett. So we had this discussion of fisking a while back.
I don't know what that is.
So I had to ask her what it was, and I actually Googled it to make sure I had the right definition. But fisking, the process of shredding a written argument line by line, parsing the meaning, and providing counterpoints. So their instructor provided the class different articles about you, and they have to go through now and fisk the article. And she said, okay, so here's the whole text. I have to fisk an article on Judge Barrett, and honestly, what an amazing woman. So I just want to share that little bit of encouragement that while there may be others on this committee that disagree, I would share with you that there are thousands upon thousands of young women out there that see the role that you set, and I went through all of those descriptive words that my fellow members have shared through the course of these hearings, but those thousands and thousands of young women that see you as someone they can aspire to be. And I know that she is in a very diverse group of friends. They are racially different. They are religiously different, but they're all young warriors, all of these young women. But they are very excited to have you in front of us. I would say that Many of her friends are not Republicans. They would affiliate more with Democrats as well, but they do see you as someone they can aspire to be. So thank you so much for setting such a great example for women of all different thought processes. And what words of encouragement would you like to share with the young women like my daughter, Libby?
I think I would say to be confident, to see what she wants, to have a plan. One thing I've often told my own daughters is, that you shouldn't let life just happen to you or sweep you along. You should identify what your objectives are and identify the kind of person that you want to be, and then make deliberate decisions to make that happen. My dad used to tell us not to make a decision is to make a decision. So I would say make decisions, be
Wise.
confident, know what you want, and go get it.
That is fantastic. And, I have 4 tenets that I live by, or pillars of success. And those 4 pillars are leadership, service, prudent risk, and gratitude. And so, I would like just to give you a couple minutes. You've already spoken to a few of those. You've talked about service and what it means to serve your nation. And you actually went through prudent risk in deciding to subject your family, your friends, yourself to this process, but deciding it was for the greater good. I'd like to give you just a moment to express some gratitude as well for those that have helped you get where you are today, and share maybe how they mentored you along the way.
Sure. Well, I think, as for probably so many people, my parents are the ones who I would have to express the most gratitude for, because, they encouraged me at every step of the way. They've encouraged me and supported me and loved me and shaped me and given the values that I have. And then as I've had my own family and my own children, then they've helped me by supporting me with my children and reinforcing what they taught me. My professors in law school, we heard the other day from former Dean O'Hara, who was gracious enough to introduce me on the panel. I had so many wonderful professors when I was in law school. I had so many wonderful colleagues once I joined the faculty. When I was in practice, I had so many lawyers that I learned so much from. And then we've talked at great length about Judge Silberman and Justice Scalia, the judges for whom I worked. And so, I guess they say it takes a village to raise a child. I think it takes a village to mentor anyone into who they become as an adult. And so I'm very grateful for the whole village that I've had that's brought me to this point.
Wonderful. Thank you very much, Judge Barrett.
Thank you. Senator Booker.
Mr. Chairman, thank you very much. Your Honor, hi.
Hi, Senator.
How are you?
I'm good. You?
I'm doing well. I'm doing well. I'm sure that part of that smile is the fact that I'm the second to last Democrat. I just want to jump right in, because I actually found some of your responses to Senator Hirono are really compelling around the public charge issue, and that you dissented in the case. And if I could read it, you wrote that at the bottom, the plaintiff's objections reflect disagreement with the policy choice and even the statutory exclusion itself. Litigation is not the vehicle for resolving policy disputes, because I think the DHS's definition is a rational interpretation of the statutory term public charge. But you were saying to her, which I really found compelling, that you were still leaving the door open for it to be capricious. Was that the word you used?
Yes, so the standard of review under the Administrative Procedure Act would be arbitrary and capricious. So I said at the conclusion of the dissent, because the majority reached both, I said at the conclusion of the dissent that I wasn't resolving that issue because it hadn't been briefed before us, but I just wasn't expressing an opinion. I thought we needed a fuller record. So I did leave open the possibility that the rule would nonetheless be arbitrary and capricious.
Yeah, as I said to you on our phone conversation, trying to read all of your cases, it has been a Herculean task, as has probably yours, preparing for this so quickly. And so maybe I can just go back to asking just a simple question that I hope you'll feel comfortable asking. It's just what I think is an obvious answer again. But do you think it's wrong to separate children from their parents to deter immigrants from coming to the United States?
Well, Senator Booker, that's been a matter of policy debate, and, obviously that's a matter of hot political debate in which I can't express a view or be drawn into as a judge.
So I respect that a lot, but I think the underlying question is actually not hotly debated, and just maybe I'll ask it one more time. Do you think it's wrong to separate a child from their parent, not for the safety of the child or parent, but to send a message? As a human being, do you believe that that's wrong?
Well, Senator, I think you're trying to engage me on the administration's border separation policies, and I can't express a view on that. So I'm not expressing assent or dissent with the morality of that position. I just can't be drawn into a debate about the administration's immigration policy.
Right. And of course, the question does have implications, but a very simple, as I said to you yesterday, that we're debating things that, to me, are basic questions of human rights, human decency, and human dignity. I'm sorry that we can't have a simple affirmation of what I think most Americans would agree on. But maybe I can jump back to something we began. Yesterday, I asked you whether you were familiar with studies conducted by the U.S. Sentencing Commission. Do you remember?
Yes, I said I was generally aware. Are you talking about when we talked about systemic or implicit bias and systemic racism?
Yes.
I'm generally aware that there have been studies done.
And so the U.S. Sentencing Commission provides non-binding federal guidelines to federal judges, which showed that some of the racial disparities in our criminal justice system, they talk about that considerably. And my colleagues and I on both sides of the aisle, as we worked on criminal justice reform, discussed a lot of them. And some of those, as I discussed yesterday, were examples that federal prosecutors are more likely to charge black defendants who carry, with offenses that carry harsh mandatory minimum sentences, they're more likely to charge black defendants than similarly situated white defendants. And black defendants were subject to 3 strikes laws, sentencing enhancements at a significantly higher rate than white defendants, which on average actually added 10 years to their sentence, a significant surrender or seizing of liberty. And you said you were not familiar with that particular study, as you just reaffirmed, or the facts that they cite in the study showing that interracial bias is present in our system. And I think in our discussion, I think it came out that that these issues of bias in our criminal justice system are manifest really in many different aspects of the system, from police misconduct, unlawful use of force, to prosecutorial bias, sentencing disparities. These are wide and vast areas that have been shown to have such implicit racial bias evident in them. And this year, clearly, we've been grappling as a nation with a lot of these issues, and it is a part of our long-standing history. You cannot divorce the role of judges in our history over these some 200 years, and how race has been a persistent part of the national narrative, grappling with deep issues of bigotry and bias, overt as well as the biases that exist. We know that many of the unjust deaths of unarmed African Americans at the hands of law enforcement have brought this even more into public concern. And so I just want to ask you, and maybe give you more of a chance to discuss. I understand that you weren't aware of specific studies I cited, which are central to the important work of the U.S. Sentencing Commission, which advises federal judges or provides recommendations to federal judges. So I just want to give you an opportunity today to share what studies, articles, books, law review articles, or commentary you have read regarding racial disparities present in our criminal justice system.
Well, Senator, as you know, the sentencing guidelines do give judges guidance on imposing sentences, and so I am familiar with the sentencing guidelines because there's something when we review sentences that, we need to draw on and apply. In addition to the sentencing guidelines, the Sentencing Commission, as you say, does issue studies, or sometimes we get things from the Federal Judicial Center that talk about it. it's not something, I'm certainly aware of it. I think it's kind of an obvious point that there's
Right,
still
but
racism.
but
I
and forgive
hadn't-
me for interrupting, and I'm especially
No,
concerned because
that's
of
fine.
Joni Ernst, who's been teaching me about Iowa, and I do not want to make her mad. I was actually asking specifically any books you can name that you've read on this subject, or law review articles, anything that you specifically read outside of the sentencing guidelines.
Well, Senator Booker, I would say that what I have learned about it has mostly been in conversations with people, and, at Notre Dame, as at many other universities, it's a topic of conversation in classrooms, but it's not something that I can say, yes, I've done research on this and read X, Y, and Z.
I respect that. You've answered the question. So, one of the greatest drivers of disparities, I've worked with partners of mine on both sides of the aisle, has been the so-called war on drugs, which really is a war on black and brown people because of the outrageous disparities. And there's no difference between blacks and whites for using drugs or even dealing drugs in America, but blacks are multiple times more likely to be arrested for them. It's why at Stanford, not that I'm impugning my school, lots of drug use, very little arrests, but in low-income communities like the one I live in, equal drug use, but much more arrests. One of the most tragic examples of this, again, partnership on both sides of the aisle, was about the crack powder cocaine disparities, which imposed such harsh, unbalanced penalties for cocaine relative to powder cocaine, that someone caught with a amount of crack cocaine the size of a candy bar would get a roughly the same sentence as someone caught with a briefcase full of powdered cocaine. This is a wildly unjust part. When the Sentencing Commission wrote an amendment to the address to address some of the disparities and made it retroactive to 2008, you actually wrote a law review article in a well-known legal academic, not a law review article, excuse me, you wrote a blog post in a well-known legal academic that cited this decision, and you questioned whether that was a wise call. Now, in fairness, as I reread it today, you raised the administrative hurdles in retroactively reducing sentences, which would provide relief to actually an estimated 20,000 Americans who had their liberty, one of the most fundamental rights, taken away from them. But never in the blog article did you mention that this was unjust. There was no deference to how serious this is for the 20,000 Americans, 98% of them who are black and brown. You just questioned, why are we doing this? Could you tell me why?
Sure. Senator Booker, I think what you're referring to is a short blog post on the Law Prof's blog, and it wasn't an in-depth exploration of the crack cocaine disparity or anything like that. It was simply pointing out the administrative hurdles because my husband was an AUSA, a federal prosecutor at the time, and that had been table talk at our house, just kind of the complexities of retroactively going back. So it wasn't a policy statement, and it wasn't a statement meant to be just. I don't think it was probably more than a paragraph. And it was simply identifying the administrative hurdles because they're clearly, whenever you apply retroactive reform, there are administrative hurdles going forward.
Well, you're a law professor who assigns lots of syllabus to just a guy like me who played football. This is a long article, a couple pages worth, and I'm wondering.
The blog post was?
I have it here in font that my old eyes can't read without glasses.
My old eyes can't see it from here either. I don't have a memory of how long it was.
I guess I'm just saying that you're not citing articles or research that you've read on this issue, yet you have written here about it. And to me, that speaks, it makes me wonder and want to talk to you a little bit about your preparedness and priorities, taking the highest office in the judicial world that deals with such long-standing issues of race and in a way that affects the totality of the lives of Americans in every aspect of their life, from their financial well-being to their rights to vote. And I'd like to go through as quickly as I can in my remaining 10 minutes a little bit about the vastness of this problem and why I'm very concerned that you haven't even cited anything that you've read that would speak to this, or the only writings I could find on it don't even talk to the injustice of it all. And so you had a conversation with Senator Klobuchar about voting, and I just want to know, have you ever waited 5 hours to vote?
I have not.
Have you ever waited over an hour even?
I have not.
Yeah. Well, in Wisconsin, a state in your circuit, we saw the travesty during the primary earlier this year, during a pandemic, that many polling places were closed and lines were incredibly long. In Milwaukee, a city of more than 500,000 people located in a county with 70% of that state's black population, we literally saw out of the city's 180 polling places, only 5 were open, pushing people into hours and hours long wait. Now, comparatively, 66 polling places were open in the city of Madison, a predominantly white city, half the size of Milwaukee. And the U.S. Supreme Court made this all worse with a ruling that restricted mail-in voting at the last minute during a pandemic where black Americans are dying at twice the rate of white Americans. And let's be clear, this is part of a nationwide problem with racial disparities in voting. A recent study found that residents of entirely black neighborhoods wait almost 30% longer in lines to vote, and they were 74% more likely to spend more than that half an hour at the polling place. Now, your dissent in Cantor versus Barr, you said something about virtue-based restrictions, which really raised my concern, and that virtue-based restrictions have applied to civic rights like voting and jury service, not individual rights to possess a gun. This approach to the franchise sort of pulls up a lot of history where people used virtue-based restrictions in the past that's been very well documented in our history. Ideas that you can disenfranchise people if they don't meet certain virtue tests. And many of these tests I know you're aware of, but these are like, are you worthy enough if you can't say the whole Declaration of Independence? These are tests that John Lewis used to talk about. Can you count the bubbles in a bar of soap? You're familiar with that, I'm sure.
Senator, I want to be very clear, and I tried to clear this up yesterday. This concept of virtue, I think especially for people who are watching this who don't know about the law, does not mean that I think that people's voting rights can be taken away because they're not good people, or that I think literacy tests are okay, or anything like that. It's a concept that was present in Heller. Cantor versus Barr was not about voting rights, and I very clearly have said voting is an individual and fundamental right that is critical to our democracy.
So poll taxes, you would say, unconstitutional?
Senator, voting is a fundamental individual right that is critical to our democracy. The 14th Amendment, the point I was making is that the 14th Amendment does expressly contemplate that states might deprive felons of voting rights because it's in the text.
So you're jumping to felonies. I just asked you about poll taxes. And I've tried to point out to you with the picture of just one place or African-American community as a whole, waiting so much longer than you and I might have ever waited in lines. I'm trying to draw something here for you. So I just asked about poll taxes. Didn't get to felony disenfranchisement yet. Poll taxes, unconstitutional, yes?
Okay, I was pointing out with the felony disenfranchisement the point I was making in Cantor versus Barr. I wasn't trying to anticipate your questions. I was just saying that that was the context in which I discussed it. I think Section 2 of the Voting Rights Act, which prohibits procedures and practices.
Right. I
Poll
think
taxes
thank
fall.
you. Yeah, thank you very much. Thank you very much. You're jumping ahead, and I spent so much time on my questioning. So let's jump, though. Let's jump ahead to this. And obviously, the case in Florida that you're well aware of, I imagine, where we had significant felony disenfranchisement. I've read a lot about the history of that going back to the post-Civil War period, the fall of Reconstruction, thousands of blacks being lynched, massacres going on in our country, from the Colfax Massacre to the Greenwood Massacre, and laws being passed systematically in places to try to make it harder for blacks to vote, designing felony disenfranchisement laws, and putting those aside of the black codes, easy to disenfranchise lots of African Americans. So this is a lot of the historical origin here. Now, we see this coming to the fact that now we have places like Florida, and by the way, there are levels of disenfranchisement for African Americans, upwards of, I think in America, 1 in every 17 blacks are unable to vote because of felony disenfranchisement. I can see by your expression that's a surprising data point. I hope that you would look at that. And yet in Florida, about 774,000 people have completed their felony sentences, are now being prevented from voting because they still owe fines and fees. These are Americans, disproportionately black, are being subject to a modern day tax. In other words, if I'm wealthy enough, I can pay that. If I'm African American, disproportionately poor, I can't do that. 1 in 5 black people in Florida couldn't vote because of felony disenfranchisement. Now, this is well-documented history. I've gone through some of it. But as you are seeking this highest office in the land, I bring this full circle of our conversation because, again, another study by the American Bar Association which I recommend to you, shows that a person with a felony commitment in America is subject to 40,000 collateral consequences. In other words, we now have in America the war on marijuana. It's affected, in 2017, there were more possession of marijuana arrests in America than all the violent crime arrests combined. Overwhelmingly and disproportionately African-American people. Saw it used at Yale and Stanford, not at Notre Dame, just played them in football. But my point is you see that if a black person is not more likely to use marijuana, but they're more likely to be convicted of a felony for it at some 3 to 4 times the rate, I hope you can see that that means that they're going to be more likely to lose other liberties, other rights. It so deeply affects their lives, their voting life, their ability to raise their children when a parent has been put in a position where now, because of that felony conviction for doing things that 2 of the last 3 presidents admitted to doing, they now can't vote, they now can't get jobs, they now can't get many business licenses. This is such a deeply affecting system that is disproportionately harming one class of citizens based upon race. And so here we are in the midst of and I return to the not normalcy of this moment in American history, where you can't turn on the TV and watch basketball without courageous athletes trying to talk to the heart of America to say, please listen. Please listen. The system is endangering lives, taking away liberty, taking away your financial well-being, taking you away from your children. There are people marched in all 50 states, 18 other countries, because African Americans, when they're jogging, sleeping in their home, are being killed. And we have a nation now where we're doing a Supreme Court justice hearing, the last days of an ongoing election, to a president that can't even condemn white supremacy, where he tells white supremacist groups, stand by, where they're menacing and literally recruiting people to do so-called poll watching, which many people have sounded the alarm in African-American communities, dredging up memories of the past of people intimidating people at polling places. People protesting in our country, all leading into an election where this issue and Roe v. Wade and people's health care, all is going to be on the ballot, but yet we're sitting here acting like this is normal. And I have a great deal of respect for my colleagues, because some of my colleagues courageously have stepped up calling out studies from and articles and writings from the Heritage Foundation, from the Cato Foundation, from AEI, who've all spoke to, with data and facts, the pervasiveness of racial disparities. The America, something's going on where the New York Times bestseller list, the Amazon bestseller list had books stamped from the beginning: The Color of Law, Just Mercy, The New Jim Crow, bestsellers all throughout America as people are seeking to know what the facts are. And so I hope you understand my heart when I look at a justice who it seems that, as the fix is in, is going to serve on the Supreme Court and hasn't taken steps to understand the pervasiveness, the facts, the truth about cases of race that are going to come before you in a system right now that so many people feel like is unjust, that those words written on the building of the Supreme Court, equal justice under law, doesn't apply to them. Because they see, as Brian Stevenson says, that we still live in a country where you get better treatment in the justice system if you're rich and guilty than if you're poor and innocent. And so I appreciate the conversation that we've had. And I wish we had more time. But there's a lot of fear, as I've talked to you about yesterday. There is a great deal of concern about the way this is being done. And I just am deeply, deeply worried about the implications to the fabric of our nation, as I said to you in our phone conversation, with the way this is being handled. And so I'm very grateful with the decorum and candor with which you've answered my questions. I hope that you feel like I've treated you in the same way.
Yes, thank you, Senator Booker.
Thank you.
Thank you, Senator Crapo.
Oh, I'm sorry. My staff is just telling me I should have said this.
Without objection, whatever it is,
You and the justice are both trying to jump ahead of
whatever it is.
I appreciate you, Mr. Senator, and the work that you and I
Thank you very much.
have done. So I would like to ask unanimous consent to enter into the record the following 3 letters into the record. A letter from the Leadership Conference on Civil and Human Rights opposing Justice Barrett's nomination to the Supreme Court. A letter from 83 young people organizations opposing the nomination of Judge Barrett to sit on the Supreme Court. A letter from LGBTQ advocacy groups opposing any nomination where reasonable doubts exist on her ability to administer fair and impartial justice for the LGBTQ people. Thank you.
Thank you. Without objection, Senator Crapo.
Thank you, Mr. Chairman. Judge Barrett, good to see you again.
Likewise.
Before I begin my comments and questions, I think there was at least an implication from what was just said that you would not be sensitive to the need for equal justice for all under the law for all peoples in America. Would you like to respond to that at all before I go ahead?
I am fully committed to equal justice under the law for all persons. I am fully committed to enforcing all laws to prohibit racial discrimination. In my private life, I abhor racial discrimination, and obviously for both personal reasons and professional reasons, want to ensure that there's equal justice for all. And, you know, all of my children, I think, have made an escape, but if they watch this one day, I would want all of them to know, and especially Vivian and John Peter, that I unequivocally condemn racism and want to do everything that I can in my own capacity, personally and as a judge, to end it.
Thank you. I appreciate you making that point. I find it just incredible that a mother of children of different races could be accused of not being sensitive nor willing to protect the rights of all under the Constitution. Before I go on with my questions, once again, it's happened both 2 days ago and yesterday and again today. There's a couple of things I think that need to be set straight in the record. First of all, once again today, it was said that we should not be holding these proceedings because we should be dealing with the pandemic. Well, first of all, the Senate can do more than one thing at one time. Secondly, as I indicated before, we've put over a $500 billion package of relief dealing with most every important and significant aspect of our need for COVID response on the floor. It has been filibustered by the other side. The president has made an even larger offer back. That has been flatly rejected. And we have had an announcement recently by the leader of the Senate, Mitch McConnell, that we will vote again next week on the issue to see if there is some way we can get an agreement to move forward. But the argument that we should simply ignore this important nomination because of that holds no water. Secondly, another of the major points that this entire hearing was started out with on the first day was that people should be scared by these proceedings because they will lose coverage, health care coverage for their pre-existing conditions. That has been, again, run out here today, time and time again. And I'm not going to ask you to go through that again, but I'm going to make a couple of comments about that. As I said earlier in these hearings, even back when we were debating Obamacare, there was no disagreement about covering pre-existing conditions. And in every proposal from our side since that time, coverage for pre-existing conditions has been included. It is not something that there is an effort to or a willingness or a desire to eliminate in terms of protection, and it is not at risk in the Supreme Court case, as you have, I think, very clearly described in your testimony, Judge Barrett. And finally, with regard to that, if those assurances and those facts don't make it clear, Senator Tillis has introduced legislation called the PROTECT Act, which will put into law, once again, protection for pre-existing conditions in our health care coverage And every one of my colleagues on the other side of the aisle voted no, to stop that from moving forward. It's there. The bill, the PROTECT Act, is in the Senate. We can vote on it if we can just get permission to proceed to it from our colleagues. So this notion that pre-existing conditions is somehow at jeopardy is simply rolling out yet again in this campaign cycle, another one of the arguments that doesn't hold water. Now, I do want to move to some questions for you, Judge Barrett, and again, after it was extensively discussed yesterday and the day before, you have been attacked on the basis of concerns about your willingness to follow precedent and stare decisis. In fact, one of my colleagues, if I heard it right, said he thought that you may participate in issuing in a whole new era of judicial activism in overruling precedent of the courts and basically pushing an agenda that you won't admit to having. I know you answered this a lot yesterday. We're going to go through it again. One of the things that you were asked about extensively was this, I think, 2013 law review article where a sentence was plucked out of it that you feel was not correctly reflective of what you said and how you feel. Would you like to take an opportunity to clarify that for us?
Sure. That article was responding, so as I've said a couple times, the Supreme Court gives different precedential strength to constitutional cases than to statutory cases. And that article was responding to arguments that either stare decisis should be eliminated altogether or that it should be absolute. And I was taking the Supreme Court doctrine as it exists, you know, where constitutional cases are not absolutely insulated from overruling, which is the position that every Supreme Court justice of whom I'm aware has had. Sometimes you do have to overrule cases, otherwise we don't have Brown versus the Board of Education. And I was just identifying some of the virtues of that presumption. So I was defending in that article the current Supreme Court doctrine of stare decisis, and I very clearly said in that article that you can't just impose a new vision with votes, that you have to take reliance interests, and that always lack of certainty about how the stare decisis calculus runs counsels in favor of keeping the status quo.
Well, thank you. Now, I found it amazing that you would be accused of being a judicial activist because you are a textualist and an originalist, as I understand your testimony and your record and your writings. And I'd like to just look at a few of your writings. You have described stare decisis as a fixture of the federal judicial system. You have stated that the Supreme Court, that you recognize that the Supreme Court follows a presumption that precedent will stand and that the court does not depart from that presumption unless the precedent is not only erroneous but unworkable, correct?
And not only erroneous and unworkable, but also has to take into account reliance interests and those other factors as well.
Yep, that was actually next on my list.
Sorry, I thought you meant unworkable was enough.
You anticipated that. And you have spent a lot of time, and I won't ask you to do it again, going through those requirements that are in place before a judge or a justice would seek to become an activist in the sense of overturning existing precedent of the court. And you've also said that partisan politics are not a good reason for overturning precedent. I assume that goes without saying, correct? Let's look at those are some of your writings, and you've written much more, but let's look at some of the case law. You've got a pretty significant record now in the Seventh Circuit. You have, as I see it, a pretty solid record there of following precedent. The first issue is in 2019, you had a discussion with Judge Amul Thapar.
Oh, yes, Judge Amul Thapar.
Okay, and I think, could you please explain that conversation? It related, I think, to a case where you were clarifying that even though you disagreed in a previous circumstance relating to it, that you would follow precedent, or do you recall that conversation?
I mean, I recall the conversation. We did it for a professor in the political science department. It was to primarily an undergrad audience, and we answered questions back and forth on a range of topics. I don't remember the particular.
Okay, so this was not a case, it was a scenario you were asked about in that conversation.
okay.
And you made the clarification that in that scenario, you would decide a case, or a case consistent with the way the majority did and not with your own view if the precedent required it.
Oh, so if I had dissented the first time around
Yeah.
and lost, and then when.
That's
it came
apparently
around-
what that was all about.
Okay.
So let's talk about a couple cases. In Price versus the City of Chicago, you joined in affirming opinion over a district court's dismissal of a suit by pro-life activists. Do you recall that case?
I do.
What role did precedent play there?
Precedent controlled a case called Hill versus Colorado. The bubble zone ordinance at issue in Price was nearly identical to the one that the court had upheld in Hill.
And even though in this case you ruled against a pro-life interest in following precedent, correct?
Correct.
In Lett versus the City of Chicago, you applied the Supreme Court's test for evaluating restrictions on public employee speech. Do you recall that case? Yes. And
Yes.
again, you followed the precedent. In Chazen versus Marske, M-A-R-S-K-E, the Seventh Circuit held, in light of the United States v. Mathis and a subsequent Seventh Circuit decision, that a petitioner's prior convictions on a burglary no longer qualified as predicate offenses under a certain criminal act. Again, following precedent of the Supreme Court and the Seventh Circuit. I'm just picking out a few. You've got a very full record of these. In my view, I only found one case where you actually did not follow Seventh Circuit precedent. And that was the case of Groves versus the United States. And I don't know if you recall that case, but
I do.
why didn't you follow Seventh Circuit precedent then?
So in that case, there was precedent that was old, on point, and the Supreme Court had issued a series of subsequent decisions which called our prior precedent into doubt. And so the Seventh Circuit has a rule called Circuit Rule 40E, and when we conclude as a full court, you circulate an opinion to the full court to say, I think our precedent should be overruled, in this case because it had fallen out of step with later developments in the Supreme Court. I circulated that precedent, or the opinion pursuant to 40E, and the full court agreed. So we overruled precedent.
So the way I would summarize that is that you, the court, with your support, overruled a Seventh Circuit precedent because a Supreme Court precedent overruled that. Pretty closely?
Not directly overruled it, but the Supreme Court precedent
Was inconsistent with
undercut
it.
it.
So you were
Undercut it.
following Supreme Court precedent to take that action.
Yes.
All right, let's just look at your cases. And I'm going to go through some statistics here. You know, statistics sometimes get outdated or what have you. So if these are not accurate in your understanding, please tell me. But what I have before me tells me that you've authored 79 majority opinions since arriving at the Seventh Circuit. Is that a correct number?
I don't know. So I will take your word for it. I think
All right, well,
yeah.
that's what my information says.
Okay.
And it says that you've participated in the disposition of 922 appeals. Does that sound approximately accurate?
I think I have, the numbers that I have looked at recently suggested that I've participated in 600 panels that were appellate, but close to 1,000 matters, which would include things like stay, certificates of appealability, stay applications, et cetera.
All right. And my understanding is, and again, these statistics might vary a little bit because the numbers are a little different than you say, but I think this is pretty accurate, that your majority opinions have been unanimous 95% of the time. In other words, almost always when you join a majority, it's a unanimous conclusion of the court or of the panel. Is that correct?
That's my understanding. I've seen that statistic.
Well, the statistics I see say that it's 95% of the time that it's unanimous for the decisions of the panel. According to CRS, Congressional Research Service, in all the cases you heard resulting in a reported opinion, you've only dissented 1.84% of the time. That ranks you 6th among the 11 active judges of the Seventh Circuit, which is right about in the middle. This report also says that your reported majority opinions drew dissents 6.41% of the time, which ranks you 6th among the 11 panelists, or of the 11 active judges, right about in the middle. And it says that the reported majority opinions drew separate writings or concurrences or dissents 7.69% of the time. That ranks you 8th among the 11 active judges of the Seventh Circuit, which means your opinions were some of the least likely to draw a dissent or a concurrence. The point of all these statistics is this is not the record of someone who is an activist in overturning precedent. This is the record of someone who follows precedent. And I just want to thank you for being that kind of a judge, because that's one of the reasons I'm so glad to support you as we move forward. Now, again, unfortunately, today, once again, and I thought we had this resolved yesterday, you've been challenged on what you knew about the president's positions on various issues and whether that influenced your positions. In fact, I think it was even implied that a law review article you wrote that was probably written before the president was even president was something that you were influenced in writing because you knew what the president thought. In any event, we're going to have to go back again and ask you these questions about, you've already said yesterday that the president didn't talk to you, his staff didn't talk to you, no one talked to you about Roe versus Wade, Obergefell, or California v. Texas, and you made no commitments on those 3 cases.
I made no commitments on any of those cases or on any other case.
That was my next question. Because today it's been implied that you've basically just been following the president's statements, his tweets, even things that he may have felt or believed before he was president, and trying to make your decisions consistent with that. So once again, has the president or his team or anyone talked to you about any case or received a commitment from you about how you would rule on any case?
No, Senator Crapo.
All right. I hope that we can once again put that one to rest. And could you also once again restate, is anybody above the law in the United States?
No one is above the law in the United States.
All right. Thank you very much. I told you yesterday before I quit that I was going to ask you a few softballs.
Sometimes softballs turn out not to be softballs. Go ahead.
Well, I think this will. I just want to ask you, I'm going to go, these are some of my hard balls. I'm going to leave those because I've only got 3 minutes left. I just want to talk to you for a minute about academia. What led you to your decision to move out of practice into academia?
Well, when I was in law school, I thought I might like to teach someday because I really like teaching. I considered being a teacher. I mean, being a secondary school teacher was actually one of the things I thought about too in college. As I said in my speech at the announcement of my nomination that my mom was a teacher and my dad was a lawyer, and so combined that might explain how I wound up being a law professor. So I loved the idea of teaching students. I liked the idea of communicating with clarity, you know, complicated doctrines to them to help them. I have very much enjoyed, you know, teaching the 2,000 students that I've taught and mentoring them as young adults just embarking on their careers, and in many cases for those who have not had much time between undergrad and law school, even kind of launching their lives. It's been a really rewarding experience.
Well, you've obviously been very influential in that because so many of your students and your colleagues speak so highly of you. You actually also anticipated 2 of my other questions about it. So I only have one more to ask, and that is, what was your favorite class to teach?
Oh, it's hard to pick a favorite. It's like asking what's your favorite child, who's your favorite child. I really enjoyed teaching so many classes. I mean, constitutional law and federal courts overlapped directly with the things I was writing about. I taught evidence mostly just because they needed somebody to do it. And what's funny about that is, you know, I didn't do scholarship. I didn't write scholarship about evidence. It wasn't part of my scholarly interest, and I was doing it as service. It's called a service class just because you need someone, everyone wants to take it. It turned out to be really fun to teach. just because it was fun to be able to engage students in interactive exercises, and I could use movie clips to do it, and it turned out to be a very fun class to teach, even though it didn't overlap with the things I was writing about.
Well, thank you very much, Judge Barrett, and it is an honor for me to be able to support you for this nomination.
Thank you, Senator.
Thank you. Senator Harris, are you?
I'm here.
Thank
Can you see me and hear me?
Yes, ma'am. The floor is yours.
Thank you, Mr. Chairman. Judge Barrett, earlier today you described the Voting Rights Act as, quote, a triumph of the civil rights movement. But as you know, the Voting Rights Act was not an inevitable triumph. So I think it's important for us to acknowledge some of its history. This year, our nation has mourned the loss of a great American hero, Congressman John Lewis. He was one of our country's greatest leaders because he inspired us to fight for a more perfect union. Every year, John Lewis would invite a bunch of us, members of Congress, faith leaders, others, to join him in Selma, Alabama, for a walk across the Edmund Pettus Bridge. And it was there that he would remind everyone of America's history and the history of the fact that for generations, Black Americans were denied their constitutional right to vote. He also reminded us of the brutality that so many Americans faced when fighting for the voting rights of Black people and all people. And history reminds us that some states, as a condition of voting, require Black Americans to answer impossible questions, like take a look at that jar of jelly beans, and if you're going to vote, you need to tell us how many jelly beans are in the jar. There were questions asked of folks. In order for them to vote, they would have to tell the official how many bubbles are in a bar of soap. Impossible questions, obviously. Some states required Black people who had been systemically and systematically denied access to equal educational opportunities to answer questions like, how often is the federal census taken? Or when is inauguration day? And when one of these malicious questions was asked, they were challenged, as you can imagine, and many were struck down. But when that happened, those states and municipalities would just put up new restrictions and new obstacles for folks to vote. In other cases, Black Americans were beaten when they tried to vote or register to vote, including Congressman Lewis and others who memorably shed blood on the Edmund Pettus Bridge. That's why after so much pressure and the marching, the peaceful protest from civil rights activists, that in 1965 Congress finally passed the Voting Rights Act to end discriminatory voting practices. The Voting Rights Act, as you know, requires states and counties who had a history, this is very important, who had a history of denying Black Americans and other minorities the right to vote, to get approval from the federal government before they changed their voting laws. And for almost 50 years, the Voting Rights Act did what Congress intended. It allowed the federal government to monitor and guard against racial discrimination in states with a long history of voter suppression. But as we all know, in 2013, in Shelby v. Holder, a county in Alabama sued to strike down Section 5 of the Voting Rights Act that required Alabama to seek approval from the federal government before a state could change its voting laws. And of course, Section 5 required that of a number of states that had a documented history of voter suppression. Now, Judge Barrett, I know many of my colleagues have asked you about this case, but I think it's important we revisit it. By a 5-4 vote, the court gutted the Voting Rights Act and ended the requirement that states and localities with a history of discrimination get federal approval before changing their voting laws. What the majority of the Supreme Court justices fail to understand is that the success in combating voter suppression directly was a function of our ability to enforce Section 5 of the Voting Rights Act. So the success was due to the brilliance of Section 5 of the Voting Rights Act, which gave us enforcement capabilities and monitoring capabilities. As has been mentioned, just 2 months after the court gutted the Voting Rights Act, North Carolina passed laws that made it so much more difficult for Black Americans to vote that a federal court of appeals mentioned that it, quote, targeted African Americans with almost surgical precision. Texas also has a long history of racial discrimination in voting and was therefore once also covered by the Voting Rights Act. But after Section 5 was gutted in Shelby, Texas quickly returned to some of its discriminatory voting practices. Of the more than 1,600 polling places closed after the court's decision, at least 750 were in Texas. Texas also restricted interpretation assistance for English limited voters. And this year, the governor of Texas issued an order that limited the number of drop boxes for completed mail-in ballots to just 1 per county. Before the order, Harris County, Texas, which includes Houston, and had 11 ballot drop-off locations in a county of over 4 million residents and a county that covers about 2,000 square miles. Many people would say that it is just common sense that going from 11 drop boxes to what it did, which is to reduce it to 1 single drop box, has made it more difficult for people to vote. The Supreme Court has long recognized that our right to vote is fundamental because it preserves and protects all other rights. No right is more precious in our democracy. Any nominee to the Supreme Court must understand the effect and the fact of ongoing efforts to discriminate against Black Americans, Latino Americans, Native Americans, students, and other communities of color. Since the Supreme Court's decision in Shelby, at least 23 states have passed restrictive voting laws and have attempted to also close polling places, stop early voting, and take people's names off the voter rolls that should not have been removed. So Judge Barrett, in Shelby County, Chief Justice Roberts wrote, voting, and quote, voting discrimination still exists. No one doubts that. And my question to you is, do you agree with Justice Roberts' statement?
Senator Harris, I want to just make sure that I understand, that my understanding of what remains of the Voting Rights Act, what happened in Shelby County, is consistent with what you're describing. The preclearance requirement, as I understand Shelby County, remains in place, and what the Supreme Court held unconstitutional was the coverage formula. So some states, which in 1965 had a history of discrimination, had to get preclearance whenever they changed anything having to do with their voting procedures, and other states didn't. And I think Shelby County said that Congress can still pass a new coverage formula now, articulating the criteria for jurisdictions that are discriminating and requiring preclearance.
Judge Barrett, my question, however, is do you agree with Chief Justice Roberts, who said voting discrimination still exists? No one doubts that. Do you agree with that statement?
Senator Harris, I will not comment on what any justice said in opinion, whether an opinion is right or wrong, or endorse that proposition.
Well, I'm asking you, do you call it a proposition or a fact? Are you saying you do not agree with a fact?
Senator, I'm not going to make a comment. I'm not going to say that I endorse either the majority or the dissent in the case of Shelby County.
Well, I just want to understand, are you saying that you will, you refuse to dispute a known fact, or that you refuse to agree with a known fact?
Senator, I'm not exactly sure what you're getting at with asking me to endorse the fact or whether any particular practice constitutes voter discrimination. I'm very happy to say that I think racial discrimination still exists in the United States, and I think we've seen evidence of that this summer. But as to
engaging... Do you believe that
engaging...
voting discrimination exists based
Senator,
on race in America in any form?
Senator Harris, there have been cases. We've talked in this hearing about the Wisconsin case that went up to the court involving voting. I think anything, any opinion that I would express, and I don't mean to signal that I disagree with the statement either. What I mean to say is I'm not going to express an opinion because these are very charged issues. They have been litigated in the courts, and so I will not engage on that question.
During his confirmation hearing in 2005, Chief Justice Roberts was asked about the constitutionality of Section 2, which I think you were referring to earlier, of the Voting Rights Act. He testified, quote, "I have no basis for viewing Section 2 as constitutionally suspect, and I don't." Judge Barrett, do you agree that Section 2 of the Voting Rights Act is constitutional?
I think that Chief Justice Roberts' statement, "I have no basis for viewing it as constitutionally suspect," would be the same as mine. I'm not aware of any constitutional law existing that would create a question about it.
Thank you. As Senator Hirono mentioned yesterday, in a 2018 case before the Supreme Court, a group of workers were denied overtime pay and joined together to file a lawsuit against their employer. The corporation argued that workers didn't have a right to go to court as a group and could only raise disputes in arbitration individually. Unlike a court proceeding, arbitration is private. The process is hidden from the public and generally cannot be reviewed for fairness by a court. And in many cases, people are forced to agree to arbitration if they want to get the job. In 2018, because of a forced arbitration clause, the workers could not go to a court to fight for overtime and instead were forced to fight for overtime pay behind closed doors in a private arbitration. Justice Ginsburg, in dissent, noted that the workers faced, quote, "a Hobson's choice, accept arbitration or on their employer's terms or give up their jobs." She went on to explain that, quote, "employees must have the capacity to act collectively in order to match their employer's clout in setting terms and conditions of employment." She urged the court to consider the, quote, "extreme imbalance," unquote, "of power in our nation's workplaces and avoid further undermining Congress's passage of labor laws to protect workers and place them on equal footing. Do you recognize Justice Ginsburg's point that there is, quote, "extreme imbalance of power between large corporations and individual workers"?
Senator Harris, I'm going to give you the same answer that I gave you with respect to the sentence that you quoted me from Chief Justice Roberts' opinion in Shelby County, that I'm not going to engage in critiquing or embracing portions of opinions, especially opinions that have been recently decided and are contentious from the court.
And, you know, you've been on the bench a short time, but I'm going to just point out that I do believe, and commentators have noted, a pattern that you've had of ruling against workers and in favor of corporations. For example, in Berlocka v. Contact Transportation Services, you ruled against long-haul truckers seeking overtime pay for additional work. In Wallace v. Grubhub Holdings, you ruled against delivery drivers seeking overtime pay, forcing them out of court and into private arbitration. In Harris v. YRC Worldwide, you ruled against 4 black truck drivers who alleged their employer assigned them less desirable routes when compared to their colleagues. And Smith v. Illinois Department of Transportation, you ruled against a black worker who was called a racial slur by his supervisor. And in fact, if you go on, according to an independent analysis of your decisions, Judge, it appears you have sided with business interest over workers and consumers in about 85% of your business-related cases. Moving on, climate change, as many have mentioned, is an existential threat, and its effects are all around us. In California, we've had 5 of the 6 largest wildfires in the state's history. 31 people have been killed by wildfires in California since August alone, including at least 2 firefighters and a helicopter pilot. Across the state, over 9,000 homes and structures have been burned, and Californians have been forced to breathe dangerous smoke. All of this, obviously, during a pandemic which attacks the respiratory system. But rather than work to combat climate change, the Trump administration has rolled back environmental protections and removed the term climate change from government agency websites, including the EPA. In 2007, in Massachusetts versus EPA, the Supreme Court decided by a 5-4 ruling that states could sue the EPA for its failure to combat climate change during the Bush administration. Justice Ginsburg was the crucial 5th vote in that case. Following that ruling, the EPA responded by unequivocally finding that climate change and its impacts are a danger to the public health and welfare. Justice Barrett, yesterday you said that, quote, you have read things about climate change, but you would not say you have firm views on it, unquote. In response to Senator Blumenthal today, you said, quote, you are not competent to opine on what causes global warming, and that you, quote, don't think your views on global warming or climate change are relevant to the work you do as a judge. I certainly do believe your views are relevant, and I'm very concerned about your statements. Since the Massachusetts v. EPA case, scientific consensus has grown even more and stronger that climate change is real, and it is caused by man-made greenhouse gas pollution, and it poses significant threats to human life. If a case that comes before you would require you to consider scientific evidence, my question is, will you defer to scientists and those with expertise in the relevant issues before rendering a judgment?
If a case comes before me involving environmental regulation, I will certainly apply all applicable law, deferring when the law requires me to. And as I'm sure you know, Senator Harris, the Administrative Procedure Act does require courts to defer to agency fact-finding and to agency regulations when they're supported by substantial evidence.
Yes.
So yes, I would apply that law and defer when the law requires me to defer.
And do you accept that COVID-19 is infectious?
I think, yes, I do accept that COVID-19 is infectious, that's something of which I feel like, we could say you take judicial notice of. It's an obvious fact, yes.
Do you accept that smoking causes cancer?
I'm not sure exactly where you're going with this, but, the notice that smoking
It's just a
causes...
question. The question is what it is. You can answer it if you believe yes or no.
Senator Harris, yes, every package of cigarettes warns that smoking causes cancer.
And do you believe that climate change is happening and is threatening the air we breathe and the water we drink?
Senator, again, I was wondering where you were going with that. You have asked me a series of questions that are completely uncontroversial, like whether COVID-19 is infectious, whether smoking causes cancer, and then trying to analogize that to eliciting an opinion on me that is a very contentious matter, opinion from me that is on a very contentious matter of public debate, and I will not do that. I will not express a view on a matter of public policy, especially one that is politically controversial, because that's inconsistent with the judicial role, as I have explained.
Thank you, Judge Barrett, and you've made your point clear that you believe it's a debatable point. Mr. Chairman, these proceedings, I believe, lack legitimacy in the eyes of the people of our country. Americans are right now suffering from a deadly pandemic, and we are also suffering a historic economic crisis. The Senate should be working day and night to provide economic relief to families and not rushing a Supreme Court confirmation. We are also in the middle of an election. More than 12 million Americans have already voted. The American people want whomever wins this election to fill this seat. My Republican colleagues know that, I believe. This hearing has done nothing to alleviate the concerns raised about why this nominee was chosen and why this is being rushed when the American people deserve to be heard. So again, I would say, let us not pretend that we don't know what consequences rushing this confirmation will have for the American people. There are countless issues at stake, and to be candid, people are very, very scared. They are scared that allowing President Trump to jam this confirmation through would roll back rights for generations, scared about what it means to the future of voting rights, about what it means for civil rights, for workers' rights, for consumer rights, for climate change, and the right to a safe and legal abortion, not to mention access to health care regardless of income or pre-existing conditions. They are also deeply concerned about what this means for our nation's continued pursuit of the timeless principle, equal justice under law. And I share those concerns. Sadly, my Senate Republican colleagues are doing, I believe, great harm with this illegitimate process. And if they are successful, it has the potential to do great damage. And I believe that damage is to the people of our country and to the United States Supreme Court. Thank you, Mr. Chairman.
Thank you, Senator Harris. Senator Kennedy.
Thank you, Mr. Chairman. Judge, let's try to answer some of Senator Harris's accusations. Are you a racist?
I am not a racist, Senator Kennedy.
You're sure?
I'm positive.
Do you support, in all cases, corporations over working people?
I do not, and I think if you look at my record, you will see cases in which I've decided in favor of plaintiffs, not corporations.
Are you against clean air, bright water, and environmental justice?
I am not against any of those things. Those are policies that the Congress has pursued in many statutes, and I think we all reap the benefits of when those statutes work.
Do you support science?
I do, and I help my children with their homework when they're trying to learn it.
You're sure of that?
I am sure I believe in science, and I support science.
Do you support children and prosperity?
I support children, 7 of my own, and then support others, obviously think children are our future, support children, and yes, I support prosperity.
Do you hate little warm puppies?
I do not hate little warm puppies.
Okay, I just want to get all that clear. See, we did that in about 2 minutes.
I think that my daughter Juliet, who's 10, would want me to put in a plug right now to say I do not hate chinchillas, because we don't have a puppy in the Barrett house, but we do have a very fluffy chinchilla, and so I don't hate chinchillas either.
Duly noted. Look, Senator Harris is my friend, and I get it. She's running for vice president. But I want to address these voting rights allegations. Senator Harris has implied that some states are pristine and other states aren't in terms of discriminating against people on the basis of gender or race or ethnicity. We disagree. She thinks America is systemically racist. I don't. I think our history is the best evidence of that. I don't think we're a racist country. I think we're a country that has some racists in it. I'm very proud of the fact that our country has gone from, in 150 years, which in the grand scheme of life, death, and the resurrection is the blink of an eye, we've gone from institutionalized slavery to an African-American president. We've passed, I'll miss some of these dates, but we've passed civil rights laws in, I think, 1869, 1871, 1957, 1961, 1965, 1990, 1991. I'm pretty proud of that. But let me get back to my point. My good friend, Senator Harrison, she is my friend. I have an enormous amount of respect for Kamala. She suggested that some states are wicked and other states are pristine. And I would gently remind her that California, a state I love, I love visiting California. You got to keep moving because they'll tax you if you stand still. But I love California. But California has a deep history of discrimination against Asian Americans. California has a deep history of discrimination against Hispanics. And I'm not saying this is true, but there have been serious allegations made against Senator Harris that as Attorney General of the wonderful state of California, that she participated in racial disparities in prosecution. Now, let me jump subjects again. We've talked about precedent and stare decisis and why it's important. We need to have stability. People need to be able to rely on the law. But you're not suggesting that the United States Supreme Court never has, nor should it ever, reverse precedent if they think they got it wrong, are you?
No, the Supreme Court has always acknowledged that there are circumstances in which it must be able to reverse precedent.
And you mentioned reliance interests. How many Americans have relied on a particular decision by the United States Supreme Court as a factor in deciding whether to overturn that precedent?
Yes.
Reliance interests are not dispositive, are they?
Reliance interests are not dispositive. For example, in Brown versus the Board of Education, I mean, clearly the South had an entire system of segregated schooling built up, and so they had relied on Plessy versus Ferguson. But reliance interests were not dispositive there because you do.
There were a lot of reliance interests on Plessy v. Ferguson, weren't there?
There were. So I think Brown illustrates that reliance interests are not dispositive. You have to look at all the factors in the stare decisis test.
Okay. Yesterday, another friend, Senator Booker, Rhodes Scholar, hell of a tight end too, Stanford. He asked you if you, I wrote it down, empathize with people struggling to pay for health care. And of course you appropriately said yes. I mean, we all do. Under our Madisonian system of separation of powers and checks and balances, which branch of government is supposed to address the struggle that many Americans have to afford health care? Congress or the United States Supreme Court?
Congress, Senator Kennedy.
Let's talk just a second about state constitutions. I know you know this, but we forget sometimes that state constitutions preceded our federal constitution. Am I right? Mm-hmm. And in fact, there are parts of our federal constitution that were copied from state constitution. Mm-hmm. Having said that, there are a lot of provisions that are similar. For example, we know we have a Fourth Amendment in the federal Constitution. Many states have their own version of the Fourth Amendment.
Yes.
What happens when a state Supreme Court construes its Fourth Amendment differently than the United States Supreme Court construes the federal Fourth Amendment?
So the state is free to construe its Fourth Amendment differently as a matter of state law, but of course the federal Constitution also applies to the states through the Supremacy Clause. So a state isn't free to violate the Fourth Amendment. But one thing states often do, which I'm sure you know because of your interest in state constitutions, and we talked about the Louisiana Constitution yesterday, is that many states interpret their versions of the Fourth Amendment or other provisions to be even more protective of rights than is the United States Constitution.
So the federal Constitution sets a floor.
But not a ceiling.
So if Louisiana wants to construe its Fourth Amendment as not having any exceptions to the warrant requirement, we could do that.
States are free. They're free to fashion their policies as they want within the limits of the federal Constitution, and so the contours of the federal Fourth Amendment would not themselves prohibit Louisiana from doing that.
Yeah, why does that make sense to you?
Well, that's federalism. So my friend Judge Jeff Sutton on the Sixth Circuit has written a book called 51 Imperfect Solutions. And his point is that, we have all these laboratories of democracy, as they're called, the states, and it's federalism. Different states have different preferences. Their electorates can make different decisions in Louisiana than in Indiana than in California. And so if some states want to have greater protections, and many do, we allow those differences to flourish within the limits of the common denominator that we have, which is the United States Constitution.
And that's just respect for the states.
That is.
Okay. The federal Constitution has a state action requirement, am I right?
It does.
Okay. Would a state be free to not have a state action requirement?
I am not aware of any principle that would prevent a state from, in a statute or a constitutional provision. I mean, states can be the master of their own constitutions, right?
And what do I mean when I'm talking about state action?
State action requirement, so the only constitutional provision, I think, in our Constitution that applies directly to individuals is the 13th Amendment, which prohibits slavery. The 14th Amendment, which is the context in which the state action requirement has been explored in Supreme Court case law in the civil rights cases, means that the equal protection guarantee, or even all the Bill of Rights that are incorporated through it, like the First Amendment, only apply to the government. So when I'm teaching this to my con law students, what I tell them is that I can tell my kids at the dinner table, the First Amendment doesn't apply here, because they'll often say, like, hey, what about my freedom of speech? And I'll say, you don't have any, because in my house it is the law of Amy. So, but public universities, are different than private universities in that regard, because the First Amendment applies to government-run institutions, but not to private universities.
Yeah. I don't know what the law is right now, but I think there was a case, maybe it's been overruled, but the California Supreme Court, based on its constitutional history, has ruled that the First Amendment in the California Constitution, or the First Amendment version, has no state action requirement. It doesn't just protect you against government, it protects you against everybody. It's just crazy.
I didn't know that.
Yeah, some interesting litigation. I read somewhere that you are an admirer of Kate Chopin.
Oh, yeah.
Who is? Tell us who she was and why you admire her.
Well, when I was in college, back in my English major days.
She's Louisiana, wasn't Louisiana,
That
right?
is, yeah. That's right. And she wrote a book focused on Louisiana and a woman who comes to Louisiana from, now I can't remember what part of the South she was from, and talked about her becoming accustomed to New Orleans and its particular culture. And I very much appreciated that because, especially, as a New Orleanian, I thought it was an insightful look into what the history of New Orleans is like. And my family, my great-great-grandparents came to New Orleans from France, and my family's been in New Orleans for generations, and so its history is important to me.
Ms. Chopin had a very feminist point of view, too, did she not?
She did. So the awakening.
Sort of before her time, yeah.
She did.
Two more. Tell me what the legal authority is, if you know, for a universal injunction. We got about 600 federal judges, federal district court judges. I could be off by a few. And they not only have limited jurisdiction, but they have limited venue, if you will. They hear cases in a certain geographical area. How can one federal district court judge in a limited venue enjoin a congressional statute or a presidential executive order for the entire United States, continental and otherwise?
Well, that is a disputed issue of law that's in litigation, and the court, it's been on the court's docket, the authority of district courts to issue nationwide injunctions, so that would, take me down the path of opining on a case that, could wind up in litigation in front of me.
Okay. I got one last question.
Hope it's an easy one.
It is. It's a sincere question. I'm genuinely curious. Who does the laundry in your house?
We increasingly have been trying to get our children to take responsibility for their own, but those efforts are not always successful. So we run a lot of loads of laundry.
Well, you're very impressive, Judge.
Thank you, Senator.
I yield back, Mr. Chairman.
Thank you very much, Senator Kennedy. Senator Blackburn.
Thank you, Mr. Chairman, and thank you for your endurance today. We appreciate it. I have a couple of things for the record. A letter in support of Judge Barrett from the Republican National Lawyers Association, and then also the op-ed that was in the Washington Post September 25th. It's by John Garvey. I taught and worked with Amy Coney Barrett. Here's what people get wrong about her faith. It is, he is president of the Catholic University of America, and it is in support of her nomination and confirmation.
Without objection, while I have it on my mind, thank you for reminding me. I have a letter from Reverend Franklin Graham supporting your nomination, and Jack Goldsmith, a professor of law from Harvard. I'll introduce those two. Thank you.
Mr. Chairman?
Yes, sir.
I asked to include in the record letters in opposition to the nomination from 50 organizations on immigration, A Better Balance, and 88 other organizations support rights of working families, 320 law professors specializing in health law, disability law, and constitutional law, and the Alliance for Justice Lawyers for Good Government of over 6,200 attorneys.
Without objection. Senator Blackburn.
Thank you, Mr. Chairman. Just a couple of things, again, tying up some loose ends before we let you get on your way. Senator Harris mentioned, as did others, that they would like to see us working on COVID relief. Again, I want to remind my colleagues they had the opportunity to vote on this a couple of weeks back, and if Senator Harris chooses to come in next week, she's going to have the opportunity to vote on COVID relief once again. She mentioned the California fires, and in relation to her comments to you about climate change, I would just remind my friend Senator Harris that it is pointed out regularly that these fires occur every year. Some years are more difficult than others, and we just grieve the loss of property and life and livelihood for Californians, but we also note that California state officials have not been successful in getting their forest management plans under control. So we would note those things. Judge Barrett, I think it is no secret that the Democrats are trying to drum up a lot of hysteria about you to spread some fear and misinformation. And much of this is centered on Americans' health care. And here's the reality. Our friends across the dais here are wanting to do a single-payer government-run system. And they fear that a constitutional court would block them from taking control of health care, from taking private health insurance away from 153 million Americans. And they have centered this entire attack talking about the ACA or Obamacare. And as I said yesterday, there are 8.3 million Americans in the Obamacare program. And in addition to the 153 million that have private health insurance, there are 57 million senior Americans that have been paying in to Medicare all their working life, and they would lose that with a government-run single-payer system. And I feel like that our friends across the dais have really tried to paint you as a monster with an agenda. And I have appreciated that you have said repeatedly, I have no agenda. And we know that, as I said, they've got their goals. They have their goal on health care, for socialized medicine, for ending the doctor-patient relationship, for making a bureaucrat-patient relationship. They've even said pre-existing condition coverage would go away, which is not true. That is widely supported by Republicans and Democrats. It actually originated with Democrats in the Senate and Republicans in the House. And they've also said older children would lose their health care. Not true. Again, that has bipartisan support. But I think what has struck me the most through some of these comments is that they say that you have to have diversity in order to have equality. But what I have watched them do through this entire process of questions and talking with you and opening statements is they have chosen intellectual isolation as opposed to having diversity bring a different perspective. And to me, that is really very sad. And to my friends across the aisle, I would say that the American people are no more afraid of the ideas of a Catholic woman than they are of the words splattered on a protest poster being held by a liberal woman. They don't fear that. I've also found a few things said about you to be unnecessarily condescending, and I regret that. I know that some on the left think they can verbally pound you into submission to a more leftist agenda. I found it very curious that one of our colleagues even said that they fear you would usher in conservative activism on the courts. But one of the things that those of us on our side of the aisle continue to say, we don't want activist judges from either the left or the right. So my colleagues should be comforted in the fact we don't want judicial activism, period, end of sentence. We want jurists that are going to call balls and strikes, that are constitutionalists, textualists, originalists. That is important to us. And some of my colleagues on the other side of the dais have seemed to be quite amazed that you could balance career and family. And I would think that they would choose to praise you for finding a way to do the work that you feel called to do and balancing it all. Maybe they should be curious about how you meet the demands of family and work and friends and church and all the different balls. I know when my kids were small, I felt like I was juggling balls coming and going. And now that I have grandkids, I feel about that same way sometime. And they have been almost, unfortunately, have this tone of condescension around that there would be a woman from the political right who would try to have it all. And as I tell my daughter regularly, you can have it all, just not at the same time. Things have to get spaced out, and you take these tasks as they come. And we see that what they have done is to continue to project their thoughts, their desires, their concerns onto the American people, using words about malicious, fear, terrified, scared. The American people are not afraid of you. They wanted to lecture you. I found it condescending the way they accused you of not understanding recusal rules. I appreciated that you were quite able to defend yourself on that point. When my team and I were talking about this, I told him, yesterday I sat here, now Senator Kennedy talked to you about a Louisiana author. I thought about a Nashville songwriter. In Nashville, we say everything begins with the song, begins and ends with the song. Now, one of my old neighbors, the late, great Eddie Arnold, had this song that was a great song. It was a love song, but the title of that is very applicable here. The song was called You Don't Know Me. And in one of our visits one day, I asked him about the story behind the song, which many times is more interesting than the lyrics themselves. And he said the story behind the song, what he had shared with the songwriter who wrote it, was that many times we miss the richness of a relationship because we don't stop and take the time to get to know someone. And that, I think, is what my colleagues did to you. They made this all about the Affordable Care Act. They made it all about issues that they wanted to talk about because we are 20 days away from an election. And what they did was, in the projection that they did, projecting their thoughts onto the American people, they projected stereotypes onto you. Those stereotypes are what they think about us as women on the political right. And they enjoy being able to mock and to ridicule and to diminish and to demean. To them, it is political sport. It is the politics of personal destruction, and it is wrong. It is wrong. I think one of the things that really gets them is this. You don't fit into their elitist format. You're a girl from the South, from New Orleans. You went to school at Rhodes in Memphis. I don't know if my colleagues have ever been to Memphis or ever been to Rhodes, which is a wonderful school. But you don't fit into their Harvard Ivy League type group. You're not a part of the clique or the club. So you left Rhodes, you go to Notre Dame, and people look at you and say, exceptional. She is doing great work. We're going to help her to get to a different spot in her career. And they did. They opened doors. You came to D.C. You clerked. But, Judge, you messed up. You went back to Notre Dame. And you chose to teach and to have a family and to have friends and a sense of community right there in the middle of the heartland. And see, now they don't want to admit you got where you got. You earned it. Nobody gave you a shortcut. You earned it. And that is why we are so honored to support you. Thank you.
I'd like to associate myself with those comments, Senator Blackburn. I'm going to tell you about where I grew up. I don't know why. It just seems to be a good way to end this thing. It's got nothing to do with anything. But I grew up in a small town called Central, South Carolina. And the first of my family to go to college, my dad owned a bar, a pool room, and a liquor store. And my mom ran the bar, and my dad ran the liquor store, and when I was old enough, I ran the pool room. This is why I think I'm a good senator. It's good training for this job. But I remember, speaking about country music, we had a piccolo. You know what a piccolo is, Judge?
I don't know what a piccolo is.
Well, you're too young. Piccolo is something you put money in to listen to the song. And the one song that I remember to my dying day, talk about country music titles, was "My Wife Ran Off with My Best Friend and I Miss Him." So this is a wonderful country. And I just want to say to my Democratic colleagues, I have lost sleep over this hearing. I did not know how it would go. There's a lot of tension. 2020 is the year that is unbelievable in every fashion. You've asked challenging questions of the nominee. You've asked probing questions of the nominee. And at times, you've done some of the things that Senator Blackburn talked about, in my view. But thank you on behalf of the country for allowing us to get through this hearing in a fashion that I think is befitting of the Senate. To my Republican colleagues, thank you for being patient. But this is not about us, it's about you, Judge. I will end where we began. The hope was not to really change anybody's mind. I don't think that's possible in today's environment, and I say that accepting 2020 for what it is. But I'm hoping that people who did not know you better. I'm hoping that young women who are conservative see hope in you, what Senator Blackburn said. I hope people who've listened find your disposition reassuring. You're one of the most amazing human beings I've ever met in my life. And that's saying a lot because I've got to meet a lot of incredible people as a senator and otherwise, serving in the Air Force. Your knowledge of law is just unbelievable, deep and wide. Your judicial philosophy, I think, is very mainstream. You're exactly who a Republican would be looking at picking, not so much a Democrat. And that's not a slam on you because elections have consequences. And to my good friend, Senator Whitehouse, I want to reform the system. It needs to be reformed. But nobody had to spend 15 cents to tell me that you're qualified. I figured that out on my own. I followed your career from afar. And this is the first time I've really had a chance to interact with you. And all I can say is that I've seen a lot of people come and go. We've had some of the most talented people in this country sit where you're sitting. And you've acquitted yourself well. You have much to be proud of. Your children have much to be proud of in their mother. Your husband has much to be proud of in his wife. You have much to be proud of in terms of how you served your country thus far. And with Amy Barrett, the best is yet to come. So, in another time, in another place, you would get everybody's vote. It's not about you. It's about us. Somehow we have lost our way. There's no use blaming one side versus the other. It always seems to be that our people get treated pretty harshly. I voted for Sotomayor and Kagan because I saw in them the qualities that a Democratic president would be looking for in the character, the integrity that the public would appreciate and would be fitting of the job. Elections do have consequences. This vacancy came about through a tragic demise of one of the greatest women of any time. She did things that no other woman was able to do, and through her actions paved the way for women to achieve their goals. She has a different philosophy than you do judicially. That is okay. I hope it's okay that you can be pro-life and adhere to your faith and still be considered by your fellow citizens worthy of this job. I think you have met every test that any reasonable person could impose in terms of qualifications. I think you made every test in terms of disposition and character that the public could hope for in terms of having somebody sit at the table at the Supreme Court. You will be confirmed, God willing. You will have my full support. I see in you someone who's not only highly qualified to be in the court in every way possible, but somebody that has broken new ground in a positive way for the country. So what we will be doing now is go in closed session. The FBI evaluation will be presented to the committee. That's standard practice for every nominee. We will meet again here just in, where's the room? Dirksen G50. You will be with us. We do this for every nominee, going back to Chairman Biden. And it is over. The hearing part is over. You can have 2 glasses of wine tonight if you like.
Mr. Chairman,
Yes.
I'll defer to Senator Durbin if he wants to go first.
Yes, I would just like to finish my thought, then we'll defer to Senator Durbin. The hearing part is over. You acquitted yourself well, but the journey you're about to take is going to be challenging, it's going to be rewarding, and may God bless you in this endeavor. Senator Durbin.
Mr. Chairman, on behalf of the Democratic side, I won't speak for Senator Blumenthal. He can certainly add his own comments. Thank you for your fairness in this hearing. I've heard no objection, nor will I, about the way you've conducted this. You've given everyone a chance to express themselves. You've been a little flexible on the time, and I thank you for that. It is a hallmark of what you've brought to this committee, and I hope it continues through the remainder of this negotiation and deliberation. To Judge Barrett, thank you for being here. This is an ordeal, and I've seen it from this side many, many times. And I want to thank your husband and your family for joining you in this effort. I'm sure they'll take away many memories, and some will be good, of this experience, which you can talk about for years to come. I do want to say one thing that was mentioned yesterday that always strikes me, and that is the impact of this experience on your children. I heard you or someone say that it was painful, there were painful moments for some of the kids. I'm sorry. I hope that I was not the cause and we were not the cause, but I will just tell you, they are innocent victims and they should not have to go through this, but each of us in public life can tell you back a story or two as well of our own family experiences. We put our names on the ballot, we're the targets, and when they go after my family, it just infuriates me, just drives me crazy. It happens, and sadly, it happens too often. But thank you for being here.
Thank you for your kindness, Senator Durbin.
Senator Blumenthal.
Thanks, Mr. Chairman. I want to join in Senator Durbin's remarks, thanking you for being here. I also have additional remarks. I'm assuming, Mr. Chairman, that at the beginning of the session tomorrow, we'll be permitted opening statements.
I am
and
glad.
rather than taking time now,
Yes.
I will have comments on the process and on comments that have been made by others, President Trump, by some of our colleagues here today, and over the course of recent days. But I do thank you, Mr. Chairman, in giving us that opportunity first thing tomorrow before the markup begins.
So, thank you very much. We're going to meet tomorrow at 9 o'clock. We'll have an executive business meeting. We're going to hold the nomination over consistent with the practice of the committee, and we'll talk among ourselves tomorrow and give everybody a chance to express themselves. We've got a panel, 4 and 4, 4 for, 4 against. We'll hear from them. We'll hear from the ABA, and we'll meet tomorrow at 9 o'clock, and we will gavel this part of the process to conclusion. We'll meet in Dirksen G50. God bless you. Judge Barrett, thank you very much.
Thank you, Chairman. I plan on it.
My bad.